Hello, everyone. Welcome to New Statement of Decision, Statute and Rules, Tips to Prevent Mistakes. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am delighted to introduce our speaker, Claudia Ribbett. Claudia is a partner at Ribbett and Silver and counsel at Complex Appellate Litigation Group, LLP. She is one of only a handful of attorneys in California certified as a specialist in both appellate law and family law. Her practice focuses on complex dissolution matters, including asset division, business valuation, child custody, and spousal support, with substantial experience before the California Court of Appeals. Claudia is a fellow of the American Academy of Matrimonial Lawyers and at the International Academy of Family Lawyers, and has been recognized as a super lawyer for many years. We're so excited to have her with us today, so I'm now going to turn it over to her.
Thank you, guys. I'm actually one of maybe 12 now lawyers who's dual certified in the state of California. And also another academy took me in, the California Academy of Appellate Lawyers. So, oops, I get very small now. So this this discussion of statements of decision isn't the hottest and sexiest topic in the world, but it has gotten much, or will get in January of 2027, thank God, much, much easier. Because I used to say that the rule for statements of decision, CRC 3.1590, was Kafkaesque or Byzantine, and nobody could understand it. And I used to have a complete copy plastered on my wall, and I would look at it even at in my level of experience multiple times a week. It's gotten much easier. I don't mean to be simplistic, but I will go back for just a second to say, what is a statement of decision? Can you move the slide? A statement of decision is the court's factual and legal basis for its decision on anything that's controverted as an issue at trial. It is not an order of the court. It's not an appealable judgment. It's going to become much easier under the new rules to figure out what is an appealable judgment or what isn't. Several times a month, someone will ask me whether they need to appeal from a statement of decision, and the answer is 99.9% of the time, no. So just remember that after a court has issued a final statement of decision, either now until January or under the new rules and new statute, ask the court to issue its final judgment if for some bizarre reason the court hasn't done so. So next slide, please. When do you get a statement of decision? You get a statement of decision in any non-jury proceeding, which is always us, where a question of fact is being determined. It's generally not required for a motion or an RFO, even if an evidentiary hearing is held. This, of course, has some exceptions. One of the exceptions, which is not on the next slide, Susie, can you move, please, is a DV case, but it is my judgment and advice that if you're holding a large DV hearing, a small DV hearing, any kind of domestic violence protection order hearing, ask for a statement of decision. Um, so please, yeah, thank you. Move to the next one. When are you otherwise in a non-DVRO arena entitled to a statement of decision? When you have a bifurcated issue tried to the court. What is the date of separation, whether a premarital agreement is valid or invalid, and you're holding a hearing on this issue with witnesses under CRC 3.1591, which we'll talk about a little bit later because it too has some small modifications, or will have some small modifications when you have a bifurcated issue to be tried to the court, or that's being tried by the court. You are entitled to a statement of decision. We can talk some other time in some other place what you do if you want an immediate appeal from a bifurcated issue that is the subject of a separate order for bifurcation. That is not the subject of today, but that also has its own kind of complicated rules. So equitable claims tried to a bench trial, we don't really need to worry about that at the moment because all of our cases are equitable claims tried to a bench trial. Custody determinations, under Family Code Section 3022.3 and and cases including in re Rose G are 100% of the time entitled to a statement of decision. So if you have a small, large, medium size child custody trial, you ask for statement of decision under 3022.3 and you're going to get one, or better get one, or should get one. Next slide, please, goes into the important question, which probably all know about, but I'm going to take a moment to remind us, is why do you need a statement of decision? You need a statement of decision because of the doctrine of implied findings. In the absence of one, the appellate court is going to presume that the trial court made each and every factual finding necessary to determine, or rather to support the judgment for which substantial evidence exists in the record. That means if you didn't ask for a statement of decision and didn't ask for the court to lay out every single factual finding that it made, the Court of Appeal is going to presume that such a factual finding was made. Sometimes it wasn't made, and sometimes you need to ask the court to tell you what it's doing, what it's saying, and what it's making, because otherwise, all necessary findings of ultimate fact in your trial are going to be implied, meaning the Court of Appeal is going to say, I'm implying them, and the only issue on appeal is whether the implied findings are supported by substantial evidence. And that's a much more narrow standard of review and a very difficult burden, or rather standard of review, to get a reversal on appeal. So next slide. Here's an example. It comes from negligence cases, which we are not dealing with, but it's kind of an easy, non-specific way to explain it. In a negligence action, a court has to find there was a duty of care owed to somebody. There was a breach of that duty. The breach of that duty was the cause of an injury, and the victim incurred damages. If the court finds the defendant negligent, but doesn't issue a statement of decision, the Court of Appeal is going to assume that the trial judge found each and every one of those ultimate facts to be true. There was a duty, there was a breach of the duty of care, and the victim incurred damages. So you can imagine, and say, in a custody case, if you don't ask for a statement of decision on whether one parent was withholding the child or one parent was likelier than the other parent to provide for close and continuous contact between the child and the parent, and the judge finds that one parent should have primary physical custody, the court's going to find everything else that you may not believe was tried in the case in order to support that judgment. So it's important not only to ask for a statement of decision, but to be very mindful and careful about what you're asking or how you're asking for a statement of decision, which we'll talk about a little bit going forward. And I'm not here to seed my own bed, so to speak, but I'm happy to help people in post-trial areas, including drafting requests for statement of decision. I do maybe 40% of my 100% of my appellate work is helping trial lawyers at all stages of the proceedings, because I am a trial lawyer. I was a trial lawyer. I'm mostly now an appellate lawyer, and I like helping, and I can help. I also answer the phone sometimes and just give you an answer, not on a fact-specific question, but some general question. If you have a quickie question to ask me, I will certainly answer the question. So next slide, please. So the statement of decision process is two-step. First, you have to ask for a statement of decision. And then once the court issues a statement of decision, a party must bring omissions or ambiguities to the court's attention before entry of judgment or in conjunction with post-trial motions. This is exactly how one can mess up in failing to preserve the record for appeal at the trial court level. Namely, you ask for a statement of decision, the court produces something that isn't full enough or isn't complete enough, or makes material or even immaterial errors that you want corrected and you fail to bring it to the court's attention before the judge issues a judgment, or rules on a motion for a new trial or a motion to vacate or to set aside or any other post-trial motion, you have just waived your probably, largely, or likeliest waived your argument on appeal. So waiver is a bad word and one that I try to avoid for my clients and myself at all costs. So next slide, please. So before I go into the good news, I want to talk about the old news, which is the current news. So we're in June, almost July. We have whatever many months left. The current rules are so convoluted, as I mentioned before, that first the court announces a tentative decision. It can be theoretically as easy as I find that mom should have primary physical custody. Step two is issuance of a proposed statement of decision. And after the tentative decision, it's not a tentative decision, it's not a statement of decision, it's not a proposed statement of decision. After a tentative decision, the court can change its mind at any time, and you are to ask the court after a tentative decision for a statement of decision to include, and you put a whole bunch of requests in your statement of decision request. The rules are so convoluted now that it's sometimes difficult to figure out how you get from this oral or written tentative decision to the proposed statement of decision, and you can pull your hair out. After the judge issues or the orders a party to issue a proposed or draft rather, a proposed statement of decision, parties currently are given an opportunity to object to the proposed statement of decision, and then the court issues its final statement of decision, which people try to object to. There's no grounds for that under CRC 3.1590. People do it anyway, but people shouldn't do it. They do it, and then a judge issues a judgment or order, and you can oppose that too. This slide has a typo in it. It says that on the first bullet point is fine. Governor Newsom signed into law AB 515, which totally changed Code of Civil Procedure 632, which is our statement of decision statute, and 664, which is our entry of judgment statute. But the next bullet point has a typo. It says, although the rules of court 3.5190 haven't been amended, the Judicial Council was directed to do it. It's 3.1590, and the Judicial Council is doing it. I was just participating with the Bay Area Bar Association in sending the Judicial Council our comments to the proposed new rules 3.1590, which I absolutely will talk about later because they are not as Kafkaesque, but they require a little bit close scrutiny. They aren't final. It's going to be a whole lot easier, but I'll talk about what it looks like they're going to be when they come out. Next slide, please. So under the current rules, as I mentioned, a party has to request a statement of decision within 10 days of the announcement of the tentative decision, or, and this is where people do get stuck and make errors, if a trial is less than one day before submission. And there's that typo again. I don't know how that keeps coming up. I must be slight dyslexia, which I didn't know that I had. It's 3.1590 D and N. So a court issues a tentative decision or orally announces one, and then within 10 days, you're supposed to ask for a statement of decision. What is going to change? This is the biggest problem, or this is the newest news and the biggest change, and one that is the subject of a lot of cross discussions in my law firm and among family law appellate lawyers in general, which is that under the new law, all requests for statement of decision have to be made prior to the submission of the matter for decision, regardless of the length of the trial. That means when you're exhausted and you've made sure that all your exhibits are in evidence and you want to go home, you need to remember to ask for a statement of decision before the court says so submitted or the matter is submitted. You need to read the new statute. I'm going to talk about it a little bit later, but it bears, again, close scrutiny because it's a real toughie. And what's the toughie? Well, how do you know what you want to ask for if you don't know if you've won or lost? In the olden days, when the rules were more Kafkaesque, and you looked like you were going to win, or you knew you were going to win because the court issued a tentative decision in your favor, there would be a valid question as to whether you even wanted a statement of decision. Because if all presumptions are read to support the judgment and you're the absolute drop dead winner, then why would you want the court to make it easier for the other side to appeal? You wouldn't. You just might not want to do that. You might want to keep mum and not say a word about wanting a statement of decision or further findings of fact and conclusions of law that a statement of decision provides. You don't have that luxury anymore under the new rule. If you don't ask for a statement of decision before the matter is submitted, and obviously, by definition, before you get a ruling, then you're SOL for getting a statement of decision. And there is not one of us 12 dual certified lawyers who's going to want to let that happen. So um, back in the prior, currently, and until the law changes, if I thought that I was going to be in a short trial, or if I'm helping somebody who's going to be in a short trial, and you don't know if it's less than 1 day and you need to provide a request for statement of decision before submission, I would draft a very simple document entitled Petitioner or Respondent's Request for a Statement of Decision. And you can make it kind of very broad and maybe leave some space in between your paragraphs. So as you're sitting there at the hearing, you can maybe interlineate in a handwritten manner and then file up with the bailiff a request for a statement of decision on custody, division of property, breach of fiduciary duty, whatever the trial happens to be dealing with. And maybe the same thing will be correct now. You'll go to court, even if it's a 8-week trial, and you'll have a very bland request for a statement of decision, which you may or may not be able to amend later, at asking for what you want, which is a statement of decision on whatever you just tried in the hearing or in the trial, and that's going to be tough. I think it's going to be the subject of some decisions in the Court of Appeal, certainly some discussion among bench officers, and we'll see how it plays out. As I say to people sometimes, I'm kind of driving ahead of my lights here because I don't really know how it's going to play out. I just know that it's going to be an interesting problem that requires close scrutiny. Next slide, please. What does a statement of decision have to ask for? It has to ask for those controverted issues as to which the party is requesting a statement of decision, and that is true now, and it's going to be true also in January. It doesn't have to be a detailed list of questions. It's sufficient if the request states the specific issue, e.g., was the defendant negligent, e.g., was the wife withholding the child, and the factual issues in controversy. Judges historically push back at detailed lists of questions, and there are cases that say exactly that the trial judge doesn't have to answer interrogatory questions. So you need to walk a fine line between covering yourself and pissing off the judge so much that she or he doesn't give you what you want him or her to give her or him to give you. I used to give a talk that said the most important thing you could do as a trial lawyer with your appellate lawyers win. So, your appellate lawyer wants to be the respondent's lawyer, not the appellant's lawyer, although of course I'll do both. So if you're going to win, if you look like you're going to win, hang in there and don't piss the judge off. Next slide, please. As I said, and we'll probably say another time during this conversation, under the current rules, the court has to first announce a tentative decision, and then there's a complicated process for issuance of proposed and then final statement of decision. That's got that silly typo again. And I said, hooray, all of that's eliminated under the new law. And that is a really big hooray. So the next slide gives us what we have to do in the future, which is imminent, and we ought to get used to it now. In the future, when a party requests a statement of decision, the court must issue a written statement of decision, or if the trial is less than, whoa, wait a minute, this is wrong. This is the old rule. I just made a terrible mistake. Nope, I didn't make a mistake. In the future, when a party requests a statement of decision, the court issues a written tentative, or if the trial is less than 1 day, the court can make an oral statement of decision, or the court can order a party or parties to prepare a draft. But even if a party prepares a draft, the court has to issue the statement of decision. And although the term proposed statement of decision is a matter of past history, or will be a matter of past history, the statement of decision isn't final upon issuance, but still subject to modification before the judgment by way of objections, or if the judge wakes up in the middle of the night and decides that she or he has done something wrong and she or he wants to change it, because she or he always has the right to do it under Lefrancois versus Goyle, and can wake up and say, oops, I made a mistake. I'm changing it. I'm changing my decision because a judgment has not yet issued. New new slide, please. So a detailed discussion of evidentiary facts doesn't have to be made. The court only has to talk about ultimate facts, so long as the statement of decision disposes of basic material issues in the case, it's going to be okay. Next slide. Okay, this is important. This is where I do a lot of my work. To avoid the doctrine of implied findings, a party has to object to any omissions, ambiguities, or errors in the court's factual findings and its statement of decision. Do not simply disagree and say the court got it wrong, and don't try to re-argue the merits of the court's decision. When I help people do objections to the statement of decision because the court inadvertently got something wrong, I will refer the court to the piece of evidence, either an exhibit or some testimony, hopefully with a transcript with citations, so the court can say, she's right. I did this particular thing incorrectly. I'm going to change this, and I'm going to uphold the objection to the statement of decision. Doesn't happen a lot because it's very difficult to get anybody, judges, spouses, friends, children, to agree that they made an error or to change their mind. It's human nature. But the best thing you can do is gingerly and respectfully point out where the evidence is incorrect. And I often, when I am objecting to the statement of decision, not only do that, but also provide a proposed alternative. Instead of saying X, why don't you say Y? And the court can ask for parties' briefs on statements of decision in Word. I know several bench officers in Los Angeles County do that. And then the judge can pick and choose, cut and paste from people's drafts, and save a lot of work and time, which is obviously good for the court and good for your client. Next slide. Under the old rules and until January, a party may object to the proposed statement of decision within 15 days after it's been served. So there was a 10-day request for a statement of decision, a 15-day request for objections, then another number of days for the judgment, and then final judgment after that. That's gotten much easier, thank God, under the new law. Objections have to be served and filed within 10 days after the statement of decision has been served by the court. Period. End of discussion. And if no objections are served, the statement of decision becomes final. And like with orders and judgments now, I predict that our bench officers are going to say exactly that. If no objections are served within 10 days, this proposed statement of decision is going to become the final statement of decision of the court. So correct errors, don't raise the specter of waiver of an issue relating to the sufficiency of evidence by failing to object to something in the statement of decision that's incorrect, because the statement of decision does absolutely give rise to implied findings. And if you haven't objected, it's going to be a problem. Next slide, please. So under the old rules, the court is required to prepare a proposed judgment along with its proposed statement of decision subject to objections. Under the new law, the court may, doesn't say must, prepare and serve a proposed judgment before or after the statement of decision is final, and if so, any party may object to that proposed judgment within 10 days. So you could see that it's really important to read these, the language of Code of Civil Procedure, Section 632, because it lays out exactly the time frame and how you're supposed to paint by numbers, cross your T's and dot your I's. The proposed rules, which we'll talk about in a bit, may make it easier to follow CCP 632, but 632 is the legislation, it's the statute, it is the basis for which the new rules are going to be issued, and you should look at 632 really carefully sometime in the next 6 months. So next slide, please. I'm just going to take a sip of water. Entry of judgment. Under existing Code of Civil Procedure at 664, judgment has to be entered by the clerk immediately upon the filing of the court's decision. Under the new law, judgment must be entered within 30 days after the statement of decision becomes final, or 30 days after the filing of the court's decision, if no statement of decision is requested. Pretty simple. So in addition to reading Code of Civil Procedure 663, please read Code of Civil Procedure 664, which I didn't print here in a slide because it's as easy for you to read it as for me to read it out loud, which of course is not interesting to anybody. So just to summarize again, under the old rules, proposed judgments were issued at the same time as proposed statements of decision. And it was so complicated because the judgment and final statement of decision were ultimately required to be issued within 50 days after the announcement or service of the tentative decision, or if a hearing was held on objections within 10 days of the objections. And if you're not pulling your hair out now, you can imagine that we all are we're pulling our hair out, trying to draft out or chart out, graph out, I guess is the way to put it, who needs to produce what by when, and how do you object if the court doesn't do it right. It can be very time consuming. So before I go to the next slide, I want to take a moment to ask the following question and answer it. What happens if the court doesn't issue a statement of decision that you properly requested? Back in the old days, a long line of cases held, and I would argue that if counsel properly requests timely, that means generally, a statement of decision and a court fails to issue one, that is reversible error. Well, in, let's see, 2017, which seems recent to me, but it's really not, the Supreme Court of State of California, in a case called FP versus Monier, held that no. A trial court's error in failing to issue a statement of decision is not reversible per se. You still have to evaluate whether the error was harmless or plain error. If it was harmless error because who cares, no harm, no foul, you have to argue what? You have to argue both that you were entitled to a statement of decision and that you were prejudiced from the denial of the statement of decision, which means basically that something has really gone wrong because the statement of decision wasn't issued. How do you show that? Well, you can read Monnier. You text me or email me, and I'll give you the site. Um, how does Monnier instructs that if one or more issues in the proposed statement of decision, or rather request for statement of decision, was left unaddressed by the trial court, the more you ask for, the more difficult it may be to find harmless error. So you want to ask specifically in a statement of decision for what you want, and then you're going to argue that the court it had enough opportunities to tell us what it was doing, that its failure to do so was plain error. It's a hard argument to make just from the failure to issue a statement of decision, but it bears thinking about if you're on appeal or if your client is thinking about appeal. Now, the one exception to this FP versus Marnier holding, which is that you have to show plain error, not just that the statement of decision wasn't entered, is when you have a custody trial, a child custody matter. The exception is if a judge fails to issue a statement of decision in a trial of a child custody issue, that's deemed always prejudicial and reversible. And this site I will give you, it's City and County of San Francisco versus HH, City and County of San Francisco versus HH. It's a 2022 case, and it is at 76 Cal App 5th, 531, 76 Cal App 5th, 531. So you say to the court, you issue, please, a statement of decision. You're mandated to under Family Code 3022.3. Did I get that right? Point something, point three, I think. And if the trial judge says, no, so sad, too bad, I'm not going to do it, then you you have an argument for reversal. Of course, you'd rather win than be in the Court of Appeal. Okay, next slide, please. So these next slides are not written in stone. They are proposed. It says on every slide from here on out, proposed rewrite. And I do want to say something before I go any further, which is that in the future, there's going to be a judicial council form. It's going to look kind of like this. It's judicial council. Oops, I'm trying to do this. I'm not putting this on a slide because it's fake. I mean, it is a proposed judicial council form. It's going to be entitled Request for Statement of Decision. And that may help you. And it's certainly what you will potentially bring into the courtroom when you go to any trial that you think is going to end that day, either a short cause trial or a long cause trial. It's been 10 weeks. You'll bring it, and this is one page. It's got space here, but you could, of course, add to it. And you you present this to the bailiff and tell the court to file it. There's also, interestingly, going to be a statement of decision information sheet. It's called a Civil 175 info. Civil 175 info. Again, I'm not putting a slide up about this because it's just totally not finalized yet. But the statement of decision information sheet has 4 pages. I was about to count, and then I see it says 1 of 4. It's like 2 of 4. So it'll tell you what's a statement of decision. When can I ask for one? Why do I ask for one? Is the court required to issue one if a party asks? When is the deadline? This is a really, 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 really good thing. Is it going to do away with you? Do away with you? No. Is it going to do away with me? Probably not. Hopefully not. Because it's just a piece of paper with some answers that the Judicial Council is going to draft up, and it's not the be all and end all, but it sure is better than nothing. And this is the first time we're going to have anything like this for pro se litigants, pro per litigants, for any of us who are trial lawyers who look at the word statement of decision and want to, like put a cross up, or for appellate lawyers, because I would say, I don't know, 10% of my work, fully 10% of my work is involved with answering questions about statement of decision, drafting requests for statement of decision, objecting to statement of decision, or drafting with a trial lawyer statements of decision. So this statement of decision information sheet is going to be a great thing. And those of us who practice substantially in this field are hand in glove, rolling up our sleeves and giving the Judicial Council of the State of California as much help and input as it requests and it wants. And in addition to a piece of paper, a Judicial Council form for a request for statement of decision, there's also going to be a piece of paper entitled Objection to a Statement of Decision. I don't know if I'm doing this right, but this is also one page, which is, of course, ridiculous because the statement of decision that has been drafted by the judge or by you or your opponent is going to be, 35 pages. And this one piece of paper isn't going to do it, but it'll certainly get you started. It says, please see attachment 2, and attachment 2 is going to be a whole bunch of pages, but at least there's a form now, and at least there's a file, something that you can grab onto. Statements of decision are complicated. The one statement of decision that I can recall as I'm sitting here, and maybe the bench officer who issued it may hear this webinar someday, was in the Lappy versus Superior Court. Lappy, L-A-P-P-E, is the case that was decided on a petition for writ of mandate by my side, that holds that declarations of disclosure are not done and exchanged for mediation. They're done because without them, you can't get divorced. So they're not privileged from disclosure and a subsequent action by the Evidence Code provision on mediation confidentiality, Evidence Code 1119. Declarations of disclosure are necessary in order to get divorced, full stop. And if you're moving post-judgment or to set aside a judgment and you want to see the lies and that were made in a prior declaration of disclosure and you ask for it in a request for discovery, you're entitled to get it. In that Lappy case, a judicial officer was on the bench, of course, but also on the fence as to whether I was right or I was wrong, and issued a 34-page statement of decision that was both factual and legal, that laid out this person's point of view that declarations of disclosure were actually barred by the Evidence Code mediation confidentiality doctrine from disclosure. And so when you're objecting, or when I objected to that statement of decision, it took me, I don't know, the better part of a week or the better part of several days to get this done. I don't mean a week, day in and day out, but it was tough. So a one-page objection to proposed statement of decision Judicial Council form is not likely to carry the day, but it's a start. And let me see if I want to say anything else about the statement of decision information sheet. It's got great questions. I mean, I don't know if this is what's going to ultimately be emblazoned in paper that we get to look at. But in addition to the questions that I asked enunciated to you a few minutes ago, can the deadline be changed to ask for a statement of decision? What happens if the request isn't made on time? How can you ask for a statement of decision? What are examples of the kinds of questions that a party can list in a request for a statement of decision? And there are even examples here, like, for example, what is the basis for concluding that? Does blankety blank statute apply? If not, why not? Did petitioner establish by a preponderance of the evidence that? What are the court's reasons for granting or denying the child custody orders requested by petitioner? This is very helpful. Does the court find the respondent told the truth about searching for a job? If not, why not? The more you get into this, the more a judge is going to bristle that you're asking for interrogatory type questions, but judges are smart people and they know that if you've asked for the really seminal and important issues in the case, they're going to give you what you want. Can a party request that issues be included in a statement of decision after a different party has filed and served a request for one? The answer now, prior to January 2027 and after, is yes. Before the matter is submitted for decision, the other party can say, wait, 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 my opponent, my honored, person, my colleague, as we used to say in Boston, my sister at the bar, my brother at the bar, didn't ask for blankety, blankety, blankety. I would like you to ask for that. Who prepares the statement of decision after one is requested? How much time does the party have to serve and file it? What happens if the party's ordered to draft one and doesn't prepare it on time? If I read these, you'll go to sleep, so I'm not going to continue to read it, but it's great stuff. Okay, so uh, to this slide, the proposed rewrite to subdivision A and B say the following. Subdivision A specifies the request must be made on a proposed new form. Must be made under 632 and may be made on the proposed new form, request for statement of decision. It has to lay out it has to follow the requirements of CCP 632, which is why I asked you to read it. Subdivision B lays out the timelines, 90 days for the court to prepare one, 30 days for a party to prepare a draft, with the court being able to change the timeframes. Clarifies the court has to serve a statement of decision after a party prepares a draft, since the timeframes that we'll talk about in a minute start once for objections happens once after the court serves the draft. And the committee sought specific comments on whether the rule should include a time frame for the court to prepare a statement of decision as proposed in paragraph B1, and if so, whether it should instead apply to the court's issuance, regardless of whether the statement was initially prepared by the court or the draft. And people are talking about that right, left, and center now. Uh, the operative the operative goal is to give the court a lot of flexibility, but not to be so flexible that we members of the bar don't know what we have to do and when we have to do it. Would you kindly go to the next slide? Subdivision C involves preparation of an accompanying judgment. The committee proposed an advisory committee that refers to Rule 2.900, which specifies when a cause is deemed submitted. Just, go to CRC 2.900 and look at it. The comment is intended to assist courts and litigants interpreting the timeframes under 632. So we will hopefully get 3.1590C that talks about when the accompanying judgment specifically has to be written, so long as it follows the language in 632. Subdivision D will cover objections to the statement of decision or proposed judgment, and will address a new form for those objections, which I've just made reference to, but a one-page judicial counsel form does not it's not going to cover the field. So I'm not sure it's going to really make that much of a difference, except that it's a good place to start. Next slide, please. So under the proposed rewrite, subdivision E of the new rule, the court signs and files the judgment. Issue raised, here's an issue. If the proposed judgment is prepared after the statement of decision becomes final, and there are objections to the proposed judgment, which we know we do all the time. We are constantly making objections to the proposed judgment or filing them. The court may have very little time to consider and rule on those objections before the judgment has to be signed and filed so that 664 timeframes can be met. So in light of that potentially short time frame, the committee was seeking specific comment on whether it would be helpful to include a 30-day statutory time frame in the rule, or note that the time frame is advisory and the court can do it at once, etc. I think I'm getting a little bit into the weeds, for which I apologize, but I'm excited and I guess a little geeky about it because the old 3.1590 was basically unfollowable, if there's such a word. And this hopefully, ultimately, when it's finally drafted, will be much easier to follow. Next slide, please. Subdivision F will include allowing the court to extend time frames for good cause, permits shortening of time frames in actions under the family code. Oops, God forbid. Okay, fine. I mean, I have often asked my trial court colleagues with whom I am consulting that to please go in ex parte or in shortened time to ask the court for additional time on statement of decision rules because it can be very, very difficult to get this all done in a timely basis. Some judges allow post-trial statement of decision discussions to occur via email. I think that's becoming less and less an option and more verboten. But if you want more time, you can get it now under subdivision M, in the future under subdivision F, and it would really, really, really be a good idea to ask for more time if you need more time. Um, so there is a second rule 3.1591, which is the rule that you have to follow if you're in a bifurcated hearing, which we talked about a little while ago. So when you're in a bifurcated hearing and you go right to 15.91, as it exists now and as it will exist in the future, to ask the court for statement of decision pursuant to it, rather than to 3.1590 or perhaps cite both rules of court. The new 3.1591 is going to specify how the procedure will apply. I'm sorry, let me say that over again. How the rules in 3.1590 will apply in a bifurcated proceeding. And the committee believes guidance is still needed because we need to make or they need to make very clear that any rule that gets written or rewritten um, is in strict compliance with CCP 632 and of course for judgments 664. Next slide. Up there is no next slide, and I'm 10 minutes early, which I was told not to do. So I was asked to give any kind of there's some questions and answers here. So what is I mean, this is interesting. So what is the authority to ask for a statement of decision in domestic violence hearings? I would say that there isn't a specific rule. I'm not sure, and as I sit here, that there is a case that says that. However, if you look at some domestic violence restraining order appellate decisions, you'll see the word statement of decision in there somewhere. The authority to ask for a statement of decision in domestic violence hearings is that it is an evidentiary hearing on an issue of fact, and it most of the time will deal with custody issues, which will implicate the mandatory right under Rose and the statute that I cited to get a statement of decision where custody issues are being ruled upon or are at issue. And even if you don't have a custody issue yet, because you don't have a presumption against joint custody because of a finding of a domestic violence action, you have an evidentiary hearing on an issue of fact that is important to both parties and will guide the rights of both parties in futuro, not only for 3 years, but potentially 5 years. And it should behoove the court to issue a statement of decision on this important matter as it does for matters that are far less important than how people are restrained or kicked out of their homes or deal with their custody matters. I'm going to answer the third question first because I don't know the answer to that. Do slap motions do or don't require? I don't know the answer to that. I would be guessing that they don't because they're motions, they're not evidentiary hearings. I don't do slap motions, and so I'm not the best person to answer that question. And so ask somebody else. I mean, ask somebody who does slap motions. Okay, the next question is the judge gives his or her tentative ruling. The loser asks for a statement of decision. The judge asks the winner to draft the statement of decision. How do you get the judge to not sign the winner's draft? Is the loser's only hope that the winner doesn't do a good job in drafting the statement of decision? No. What's important is to object. The loser, excuse me, the winner has been asked to draft a statement of decision, and you get statutory CRC 3.1590 time to object. And you should take that very seriously and perhaps follow the roadmap that I gave you, which is to take out all of the transcripts and all of the exhibits and any declarations or other pleadings that were admitted into evidence and show the judge where what the winner has said was incorrect. Now, the winner is not likely to make an error or may not make an error as to the evidence. And sure, you've got a problem here because you can't ask the judge simply to change her or his mind. You can't say, well, I want to be the winner now. I don't want to be the loser. But if there is a genuine issue of law that the judge got wrong, the judge misinterpreted Lamouche, didn't follow the Lamouche factors, or didn't apply them in a way that is appropriate under the cases interpreting Lamouche, then it's incumbent upon you to point that out. It's important because, among other reasons, a standard of review based on the judge getting the law wrong is a much easier case to win on appeal, of course, because you get a de novo standard of review because the courts of appeal think the trial judges are in a better position to evaluate whether someone was lying or telling the truth. Credibility of the witness is not the purview of the court of appeal, but ruling or not ruling, but deciding what the law is the purview of the court of appeal. And the court of appeal wants to give guidance to all eight divisions of the Second Appellate District, and maybe even all appellate districts in the state of California, although, and I'm talking in other areas that aren't the subject of this, but other appellate districts do not have to follow the Second Appellate District. The Second Appellate District is meant to follow its own cases and decisions, but other districts don't have to. Although that is a very complex issue, and I may have oversimplified it, and it might be the subject for a whole different. Any other questions? Because we have time, and I don't want to cheat you out of any of the time that you're entitled to. Anybody have anything they want to say?
Let's see. I'm actually checking the help desk right now. Let's see.
I tried to be as slow as possible. There's just so much you could say about 3.1590. And Susie said to me, do you have any stories to tell about statements of decision? I told one story about the Lappy statement of decision. I helped a law firm a couple of years ago in a case that involved 5 trials, one client, 5 trials, 5 statements of decision, 5 judgments, hundreds of thousands of pages of transcripts. And the statement of decision process in that case took a whole lot of time and effort. So the goal of these new rules, both the statute and the California Rule of Court, is to make it less expensive and less onerous for people to get this done, which, as I said, I don't think will end up causing me to lose a job or be out of work, but I think it will help. A big problem, which wasn't asked of me, but I'm going to sort of talk about it anyway, is AI. So we all get comments from our clients that are AI generated. They are all not to be relied upon. Naturally, we don't. The courts of appeal are not allowed to do generative AI. I am not allowed in my appellate practice to do generative AI. That is not to say, however, that AI would not be helpful in taking a 10-day set of transcripts and putting the transcripts into your file and using Copilot, asking Copilot to summarize all 10 days of the transcripts, because that will ultimately end up helping you and your appellate lawyer in understanding at least what went on. I would never, ever say to AI, not yet anyway, and probably never. If my managing partner's listening to this, I'll get my head handed to me, but maybe in the future I might ask AI to draft a statement of decision, but I doubt it. I think the most I would ask AI to do is organize the exhibits, the testimony, and summarize the evidence on X or Y subject for me so that I can get into the statement of decision and draft it. It will be helpful in objecting to a statement of decision to take your opponent's statement of decision draft that's been filed up with the court, stick it into your computer, and stick the transcripts in simultaneously and ask Copilot if and only if you have one of those safe Copilot versions that don't go into the cloud, to please tell you where the proposed statement of decision made a mistake based upon all of the evidence in the transcript that you've loaded in. I mean, I think AI will end up helping us, but it's certainly not going to do away with us. Although in one American Academy of Matrimonial Lawyers webinar, somebody said AI is not going to do away with your job, but it won't replace you. But if you don't know how to do I can't remember now how clever it was. AI will not do away with your job. Something like it'll do away with your work. I don't remember. I'm not making much sense here. This is not a good way to end. Um, Again, I mean, I just want to say I'm willing to help. Um, I want to sort of go back to AI for a second. It's a really interesting issue. I mean, I get AI emails from people, prospective clients all the time now, telling me why their appeal is great, and they've they've put the issue through AI, and AI is telling them A, B, and C. Very dangerous to rely on it. Our law firm is telling each of us each and every published decision that's come down about people who are sanctioned, not only for hallucinating about cases that don't exist, but also more importantly, or as importantly, for incorrectly citing cases. So it's just something to be mindful and careful of in the future. And I think I really am done, unless Susie wants me to answer any more questions. Is there
It,
anything else?
it does look like we do have a few questions left in the Q&A, some new ones if you'd like to take the time to answer.
Sure, I'm
So,
happy to. Where are they?
so it looks like there's what happens when when judges refuse to rule on objections to statement of decisions. Let's
That's a
see.
good question. I mean, they have to. They are meant to. You can't not do it. I have asked my trial lawyers to go call the department, politely to ask. I'm trying to remember if I've ever asked or if I had the trial lawyer file something that says request for hearing on objection statement of decision. By the way, that is something that we didn't discuss today. I always ask for a hearing on objections to the statement of decision because it's my historical belief in life that looking somebody in the eye and explaining something openly and honestly to a bench officer makes a lot more sense than having that person read the 4 millionth piece of paper that's come across his or her desk that day. Judges do not have to give hearings on objections to statement of decision. They may do it in long cause trials where they too find oral argument a little bit more helpful than just kind of reading 25, 35, 45 pages of an objection. But I think the shortest answer to what happens if they don't rule on objections is to have both sides call the court, call the department and ask. Assuming party properly requests a credibility finding, but the court fails to make a credibility finding. Nothing, I don't know the answer to whether it's reversible error without knowing what's in the case. You know, what was the evidence? What did the parties talk about? No, probably not. I mean, reversible error usually means it's such plain error that the party didn't get a fair trial. And I'm not sure that failing to make a credibility finding when one is merely requested is a plain error. The court has it is the court's purview to find somebody truthful or not truthful. And they do that not only by saying in the record, I find you more credible than the other side. They do it by the way they rule. They do it by how they rule and what they say in their ultimate decision. Anything else, Susie?
It looks like we have one more question. The other two are comments, but towards the bottom we have, for a motion, are there strategic considerations with making a request for a statement of decision with the notice of motion or later, but before the hearing or ruling?
Wouldn't do it with the motion. The courts get annoyed by what they think is boilerplate. You know, doing it in your petition for dissolution or your response to the petition for dissolution is really almost meaningless because it isn't helpful. It's not doing anything. I would do it if you have a full-on evidentiary hearing on an issue of custody or DV or of such importance that you believe that that justice will be served by having the court give better, clearer indications of how it's ruling and why it's ruling. I would do it before the submission of the hearing, submission of the motion to the court. By the way, this issue about what's the authority for DV statements of decision is the subject of some banter between me and one of my colleagues in the complex appellate litigation group. And that means that there isn't a 100% clear answer, but stay tuned. I think there will be in the near term. And if I learn anything that tells me differently, I'll try to remember who asked the question and post a response to that person. Okay. Thank you so much for listening to me, especially when I made mistakes. I greatly appreciate it, and I'm grateful to be here.
Alrighty, this concludes today's presentation. Thank you so much, Claudia, for your time and an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.